Good afternoon, everyone. Welcome to Hot Topics in Medical Professional Liability. My name is Shelley Plate, Director of Enterprise Sales with U.S. Legal Support. With me on this panel is Sarah Scher and Bill Bauer, two very well-respected experts in the industry. For those of you who do not know Sarah and Bill, Sarah Scher is the Chief Executive Officer of the Cooperative of American Physicians and the Mutual Protection Trust. In this role, Sarah draws on her extensive leadership background in healthcare, law, patient safety, risk management, captive insurance, and medical professional liability to direct CAP's core businesses, which provide access to superior medical professional liability protection, patient safety education, and risk management services. Prior to joining CAP, Sarah was the Corporate Vice President of Risk Management Insurance, President of the Advocate Physician Partners Risk Purchasing Group, and Chair of Advocate Insurance SPC for Chicago-based Advocate Healthcare, Illinois' largest health system. Earlier in her career, Sarah worked as a trauma nurse at a Level 1 emergency department and as a prosecutor in the criminal division of the McHenry County State's Attorney's Office. Bill Bauer is a senior vice president for healthcare on the Gallagher Bassett specialty team. Bill directs and supports the growth of the claims function for the GB healthcare practice area. He brings over 30 years of experience in the legal, insurance, and healthcare industries. Bill began as a practicing trial attorney in Chicago, defending hospitals and healthcare providers in medical liability claims. He then served as vice president at CNA Health Pro, where he was responsible for all medical liability, biomedical product, and pharmaceutical claims across the country. There, he established the CNA Centers of Excellence in the areas of neurologically impaired baby claims and long-term care litigation. Most recently, Bill served as Senior Vice President, Administration, and Chief Risk Executive for Northwestern Medicine in Chicago. He also served on the Executive Leadership Committee, acted as President of Northwestern Memorial Insurance Company, and chaired various committees across the health system. Thank you both for joining me today, Sarah and Bill.
Thank you. Great to be here.
It's good to be here.
So, Bill, regarding prejudgment interest verdicts, what was the prejudgment interest statute designed to do, and what are the core principles of it as you see it?
Sure. So, first of all, it's interesting to me that Illinois is so late to the game in having a statute on prejudgment interest. Other states have certainly had it for a while, and Illinois, being a jurisdiction, particularly in Cook County, that is recognized as giving away high awards, you think they would have imposed some type of interest statute long ago, but they haven't. So what the statute really was designed to do, I mean, there's what's going on and what's really going on. Outwardly, the statute was designed to more fairly compensate injured parties by making sure that they got full compensation that went back to the date of their injury. In other words, they were injured, and so they should have been, in a wonderful world, compensated from the date of that injury. Well, that doesn't happen necessarily, and quite frankly, I'm not really enamored with that as a support for the prejudgment interest. The other impetus to prejudgment interest was to provide a catalyst for defendants to take a hard look at their cases within a period of time and make a written offer of settlement to the plaintiff, which we'll talk about a little bit in terms of the procedures of the prejudgment interest statute. But at 40,000 feet, those are the two bases for why the statute was implemented.
And what do you think the ruling means for the future of pre or post-judgment interest in Illinois and also nationwide?
Well, there's a couple things, Shelley, going on. First of all, just if I may, just go backwards a little bit and talk about the nuances of Illinois' statute, because it's different from other states. First of all, in Illinois, under the statute, prejudgment interest accrues at a 6% per annum rate from the date the lawsuit's filed. That's important because the defendant can cut off prejudgment interest by making a written offer within 12 months. But that 12 months starts to tick when the lawsuit's been filed, as opposed to when the defendant's been served. And anybody that's practiced in Illinois knows that most defendants don't get served on the day the lawsuit's filed. So there could be a significant delay, which shortens the amount of time that a defendant can look at a case and determine whether they want a written offer. And I'll explain the importance of that in a second. The other element of prejudgment interest in Illinois is just that. it allows for a defendant to either eliminate or appreciably reduce prejudgment interest by making a written settlement offer within that 12-month period from the date of filing. That's good because it allows the defendant to determine, I'll make an offer, and if the plaintiff rejects that offer and there's an award that is higher than the written offer that the defendant makes, the prejudgment interest will only accrue for the amount between the offer made by the defendant and the judgment amount. So in other words, it won't go all the way back to zero and make this huge award. If the plaintiff accepts the offer, then obviously the case is over. And this was one of the things that plaintiff's attorneys were pounding on, saying defendants drag their heels, defendants don't make offers when they should. By having this portion of the statute, it will give them the type of, again, impetus to try to settle a case. If, however, a defendant makes a written offer within that 12-month period and the plaintiff rejects it and the award is at or less than that written offer, no prejudgment interest will be applied. Now, once the statute was put into effect, there were a number of constitutional challenges across the state about the prejudgment interest statute, many of them in Cook County. All of the Cook County cases were consolidated under one judge. And on May 22nd, that judge, Judge Maris, in the case of Highland versus Advocate, declared that the statute was unconstitutional. Before I go into why the judge came up with that ruling, I want to make two very important points because I've seen some misunderstanding in the community about this. First, I think it's safe to say that prejudgment interest in Illinois is alive and well. Judge Maris's decision finding it unconstitutional is nothing more than one judge's opinion as to whether the case is constitutional or not. Interestingly, there's been about 10, I think maybe 11 other trial court judges that have declared the statute constitutional. So Judge Maris is kind of out on her own in finding that it was unconstitutional. Second, under Illinois law, by Supreme Court rule, if a statute is declared unconstitutional by a trial court judge, then you get direct appeal to the Supreme Court. You don't have to go to the appellate court. In this instance, however, the plaintiff in the Highland case did not seek interlocutory appeal or any other measure to get to the Supreme Court. So Judge Maris's decision, as well as the decision of all these other 10, 11 other circuit court judges, are just kind of hanging out there. I've also been told that two of those trial court judges who have found the statute to be constitutional have gotten jury verdicts in their cases and are holding them to determine whether they're going to apply interest on both of those cases. So very interesting. Let's go back though, Shelley, and talk about why Judge Maris found the statute unconstitutional. First, Judge Maris determined that the prejudgment interest statute invades the province of the jury and the constitutional right of any party in Illinois to have a jury trial determined by a jury and no one else. The 1970 amendments to the Illinois Constitution made it clear that the right of a jury trial was supposed to remain inviolate. The Supreme Court has affirmed that. And what the Supreme Court understood that to mean is that you can't invade the jury's right to decide what damages are. In Judge Maris's view, by allowing the court to come in and say, okay, well, here's the damage award and here's the prejudgment interest I'm going to put on top of that, invades the province of the jury. I find that rationale for the decision absolutely intriguing to me for a couple reasons. One, because I'm a geek and I don't get out very often. The second reason is because anybody who's familiar with Illinois jurisprudence knows that over the last 30 years, the Illinois legislature has made 3 efforts to try to establish tort reform in Illinois. And each successive iteration of the effort to try to get caps on damages in Illinois has been weaker than the last in terms of a legislation that could withstand constitutional scrutiny. But each time, the plaintiff's bar, the trial lawyers, have raised the fact that in Illinois, you have a right to a jury trial by Constitution, and putting a cap on a jury's award invades the province of the jury. So what's interesting to me is Judge Maris's decision now essentially says, without her saying it, sauce for the goose. A right to a jury trial is a right to a jury trial. And now plaintiffs, I'm telling you that prejudgment interest invades the province of a jury. So I just love that, because for 30 years, the defense has seen the right to a jury trial thrown up to be a barrier to tort reform, and now it's kind of going the other way. So it'll be very, very interesting to see how that turns out. The second rationale that Judge Maris employed was that the statute was violates the prohibition against special legislation. So under the statute, the only parties that are entitled to prejudgment interest are those that have suffered personal injury or wrongful death. All other tort claimants aren't entitled to prejudgment interest. So what Judge Maris found was that special legislation. You are favoring one group against another group that are similarly situated. You can't do that. Also, same side of the coin, or other side possibly, it provides two separate groups of defendants. A certain set of group of defendants that are the subject of lawsuits for personal injury or wrongful death are subject to prejudgment interest, but all other defendants aren't. I think when the time comes for the Supreme Court to decide this, both of those rationales will be very interesting for them to try to weave their way through what is already precedent in Illinois on special legislation and the right to a jury trial. I can tell you that, as I said before, it's alive and well. The Supreme Court has made no determination on whether the statute is constitutional or unconstitutional, and most of the judges, save one, have decided it is constitutional. But I can also tell you that the Illinois Trial Lawyers Association, which is a very strong group, they're a very formidable opponent, are gearing up for this. And they have already retained counsel for the ultimate appeal. They've already got counsel going in and arguing motions to try to at least win over most of the trial court judges. So I think it'll be very interesting to play out. I have to tell you, I think at this point, it's anybody's guess where prejudgment interest may come out. But I'll also tell you that the statute, even if it is thrown out, I think the fixes are relatively simple to get it to a point where it would pass constitutional muster, despite the fact that it's unfortunate because jury awards in Illinois are already above the national average. And by applying prejudgment interest on top of damage awards that are also very high, which we'll talk about in a few minutes, seems fair. It seems unfair to me. So it'll be interesting to see how that plays out. I think you're on mute, Shelley.
Shelley, I think you're still on mute, but I think you wanted to talk. You wanted to ask me to talk about the Medical Injury Compensation Reform Act of 1975 in California and how it's been replaced by AB 35 on January 1st of 2023. And so I'm happy to do that. And in order to kind of create that analysis, really want to first talk about what Californians had under MICRA since 1975, and then fast forward and talk about what we will have under AB 35 and certainly what the implications of that are from our perspective. So starting with 1975 and looking at MICRA 1975, the two major tenets of MICRA were caps on non-economic damages and attorney's fees limitations. And so under MICRA 1975, the cap on attorney's fees was $250,000 for non-economic damages per claimant. And there was one cap for non-economic damages. There were no different categories for injuries. There was no annual increase in the cap, and there was no stacking of caps. Attorney's fees, likewise, under MICRA were limited, and it was limited based on the tranche of recovery for any particular plaintiff. And so for the first $50,000 of recovery, attorney's fees could be up to 40% of that $50,000. For the second $50,000, attorney's fees could be up to 33%. And then for the next 500,000, attorneys could charge 25% of that tranche. And then anything above 600,000, attorneys' fees under MICRA 1975, fees could be as high as 15%, but no higher. Now, conversely, AB 35 reduces those protections, and the non-economic damage cap under AB 35 is an increase in the MPL and HPL cases filed on or after January 1st of 2023. And then it increases annually for 10 years. And then thereafter, there's a 2% per annum increase in perpetuity. Now, AB 35 does create two categories of caps. There's caps for non-death cases and there's caps for death cases, and awards different amounts or a different cap for each of those categories. For cases resolved in the first year, so cases resolved in 2023 that are also filed in 2023, thereby being subject to AB 35, that are non-death cases, the non-economic cap is 350. So essentially, we're going from 250,000 to 350,000 on January 1st of 2023. It increases by $40,000 per year for the following 10 years, and then you get that 2% per annum beyond that. Now, for cases that are death cases, the non-economic cap is increased to 500 and increases by $50,000 per year for 10 years, and then 2% per annum after that. Now, the interesting thing that we haven't heard many people focus on, but I do want to be very transparent today, AB 35 affords for stacked caps, and that is 3 stacked caps. The first cap for a healthcare provider, the second cap for a healthcare institution, and then there's a third cap for unaffiliated healthcare providers or institutions that commit a separate and independent negligent act. Now, AB 35, interestingly enough, also affords that the cap amount that is applicable is determined.
Thank you so much for sharing your explanation and insight on this. It sounds like there's
the alleged incident or date of the filing of the lawsuit. So again, that's a nuance that we all need to be aware of as we move forward. So what does that mean for us in California? It means that if your claim is filed on or after January 1st of 2023, there's an increase in the non-economic damages from the current 250 that we enjoy now to an immediate potential for, in non-death cases, 350 times 3 if you get all 3 stacks, so a total of 1,050,000. Now that's a 420% increase in non-economic damages in that first year as compared to MICRA 1975. And in death cases, that increases from 250, which we have now, to 500 stacked 3 times, or 1.5 million. That's a 600% increase in year 1. And then over 10 years, the non-death claims would ultimately, at the end of 10 years, be valued at 750,000 per cap, stacked 3 times, so 2.25 million in 10 years. That's a 900% increase in non-economic damages as opposed to what we have now. And in death claims, it's 1 million stacked 3 times for a total of 3 million, and that's a 1,200% increase. And again, thereafter, that cap increases 2% per annum. Now let's look at the attorney's fees. AB 35 increases the attorney's fees. We talked about MICRA having those tranches. That's all done away with under AB 35. It's a flat fee, 25% of all recovery. If the complaint is, or if the case is settled prior to there being a complaint filed or arbitration, that is an 8% increase if the complaint is filed. So without filing, plaintiffs get 25% under AB 35. If they file the case, they get 33% once that complaint has been filed. And another element of AB 35 is that attorneys may also petition for even higher fees if the case goes to arbitration or litigation. They have to ask the judge for that. So there's certainly an incentive to do that as well for plaintiffs' counsel going forward. This is a significant increase for Californians under AB 35 and California physicians and healthcare institutions alike, especially when you recognize that the increase is coupled with an increase in caps on non-economic damages and stacked caps. So attorneys get a bigger piece of a bigger pie. And in looking at attorney's fees, if you take a traditional death case and let's say a 750 economic case and a 250 non-economic case for a $1 million award, in 2022, the case is worth $221,000 to a plaintiff's attorney. If you have that same case filed in 2023 and resolved in 2023, that same $750,000 in economic damages, obviously the non-economic damages will increase in a death case significantly. The case is actually worth $749,250 to a plaintiff's attorney. That's a 339% increase in attorney's fees that the plaintiff's attorney is able to recognize. 10 years down the road, that same case, $750,000 in $750,000 in economic damages is actually worth 1.24 to a plaintiff's attorney. So 10 years down the road, that same case under AB 35, there's a 565% increase in attorney's fees as a result. So, Shelley, I know you wanted to ask about the impact of AB 35. When you change the rules of compensation, you change the behavior of those being compensated. And therefore, we believe AB 35 is going to create incentive to file not only more claims, but also to name more defendants because of the desire to reach each of those stacks. We also believe that by setting the value of the cap at the resolution date, rather than the date of the incident or the date of the filing, that creates an incentive on the plaintiff's part to delay resolution. We believe AB 35 creates a potential disincentive to resolve cases pre-litigation because plaintiff's attorneys only receive 25% attorney's fees rather than 33% of the resolution in attorney's fees. There's also the likely increase in appellate activity and costs due to some of the confusing wording and drafting of the document. I was reviewing an article from June, I think it was Risk and Insurance, which appeared to indicate that the third stack was for providers such as ambulance companies, which fall outside of the other two categories. And again, if there's that confusion already occurring when the law isn't even relevant just yet, it is not yet January 1st, you know that there will be a significant amount of appeals and appellate activity as a result of some of the wording. We know that we've had plenty of appeals since 1975 with micro, and so AB 35 promises even more. We also believe the increases likely will increase healthcare costs, malpractice expenses ultimately being passed along to the patient and through the healthcare institution. And certainly we believe that AB 35 will have a ripple effect across the country as the rollback of tort reform in one state emboldens other states to consider the same.
Thank you so much.
If you don't mind me just stepping in for just a second, micro was always looked at as the gold standard, right, Sarah? I mean, it was the other states looked to micro to try to construct what tort reform they would have. And I think that last concern, although all of it is concerning, obviously, in terms of the percentage rise of awards and attorney's fees, but those other states who were able to successfully achieve tort reform legislation, it's that trickle-down effect. That California has had this since 1970, and now they're rolling it back, and what other states are gonna follow suit in a climate where we are seeing verdicts that are just, which we'll talk about, catastrophic. It seems to be pouring a little bit of gas on a fire that's already burning pretty bright, and certainly concerning across the country.
Agree, absolutely agree.
Well, thank you, Sarah and Bill. Thank you again for both of your insight on both topics. As you said, we're going to move to catastrophic verdicts and discuss that a little bit. As you know, high awards of juries are on the rise. What do you, Sarah, what do you think are the driving factors behind this increase in large verdicts?
Thanks, Shelley. Yes, large verdicts have been around forever. However, we are seeing increasing severity on a regular basis. And I believe much of what's going on and driving severity is really social inflation. Increasing not only the number of sizable jury awards, but the legal proceedings are certainly taking longer than anticipated, and rollbacks of tort reform similar to AB 35. And I also believe that the third-party litigation funding is a significant driver of what we've seen as far as large verdicts, catastrophic verdicts. And then press releases, social media, just the destimulation of those large numbers. They seem like every time you open the newspaper today, you're seeing some massive verdict, and it helps to, it creates a normalization of those large numbers. And then income and health inequity certainly is a factor, I think, that many of our jurors are looking at as they are assessing the case values. And then government actions, taxes, regulation. And certainly we cannot discount the pandemic and the impact that the pandemic has made on juries' decisions, juries' actions, and their deliberations. And I think it's going to be incumbent on us as carriers in the marketplace to really utilize data analytics, utilize AI focus groups, many of the services that U.S. Legal Office offers to help decide how best to handle these challenging claims going forward. I think historically carriers have taken a backseat when it's come to advocacy, but I think that we're going to need to really take the helm here and engage more in policy debate, promoting legislative changes to really level the playing field and advocate for continued tort reform going forward. What do you think, Bill?
Yeah, I agree with everything that you just said, Sarah. I think that the dynamic of, first of all, in the last 8 years, across the country, we've seen more than 100 verdicts in excess of $10 million. This year alone, in the last 60 days, we've seen, I think, 15, maybe possibly more, of excess of $10 million. 2 in Cook County in the last few weeks that were each $40 million. We used to call these black swans. Now it's like this indoctrination that we're seeing massive, massive awards, and trying to get your finger on the pulse of why that's happening. I think if we look at it, I think that I think putting those causes into different buckets is important. So I have 3 that I talk about. One is atmospheric. What's going on in the atmosphere that's causing these things to happen? And then the other one is both sides of the V. What are plaintiffs doing that's allowing this to happen? And what are the defendants, frankly, not doing that they should do to try to corral this? First of all, atmospheric, and Sarah, you touched on it. I think social inflation has a lot to do with this. We always used to use when a baseball player is getting paid $150 million a year, what's $30 million for an injured party who's suffered neuro impairment? So juries get really desensitized to that, which is interesting from a third party perspective, but damning if you're an insurer or a self-insured who has to pay that judgment. I also think that the pandemic, I'd call it post-pandemic, but let's just call it intra-pandemic because we seem to still be in it. We can't quite shake it loose. Has caused some of this. We in the healthcare space, not transportation or trucking where you see some of these large verdicts, but Sarah and I we grew up in the healthcare world. The anticipation of getting a halo effect for our frontline providers, that if there were jury trials, there was going to be a lot of love in the room. We're not seeing it. What we're seeing more of from doing some jury pooling is that jurors have become a social service agency. You'll pull them after a verdict against a physician, and then they'll grab the defense attorney and say, tell Dr. Bauer that we really don't think he did anything wrong, but boy, that plaintiff sure deserved compensation. That's why I almost don't want to interview jurors anymore, because what they do and how they get to their judgments is ridiculous. So atmospheric, I think social inflation, absolutely. I think the pandemic absolutely has had an impact on this. If you look at plaintiffs versus defendants, I think, let's start with the plaintiffs. I think the plaintiffs bar, by and large, and this is coming from someone who has been on the defense side his entire career, are much better at collaboration. They're much better at sharing information. They're much better at sharing strategies and implementing those strategies. I think the defense bar just isn't as good. I think we're seeing a lot more reptile theory, that playing on the fear factor of the juror that, standard of care is no longer standard of care. Policies and procedures are really safety rules and safety for the community, so that they start to feel fear that this could be me suffering these injuries and leading to higher verdicts. I think litigation funding, absolutely, Sarah. I think there's more than 40 companies out there that have more than $10 billion invested in lawsuits. So it is a big money game, and it's allowing plaintiffs' attorneys who might be hesitant to take a flyer to get these companies involved to underwrite a case, and then they can move forward. So on the plaintiff side, that's what I'm seeing anyway. On the defense side, as I've already shared with you, I just don't think they're as good at communicating. Defense attorneys and the defense bar tends to get pretty parochial about things. It's like they don't want to share. I sit on the advisory committee for ALC, for American Legal Connections, and we're really trying to get our arms around how can we be better at this? How can we do better at confronting not only reptile theory, but the damages that we're seeing? Which leads me to another thing that I think the defense bar has to do better, and that is attacking damages. It used to be when I was growing up that as a defense attorney in front of a jury, you would never mention damages. You wouldn't even suggest a number, because you get to tell them that if they pick the jury form that they should be picking, which is verdict form A, where I grew up, it's a defense verdict. You don't even have to consider damages. So I'm not going to talk about damages. That's nonsense. Jurors want to hear what the defense has to say about damages. And if the defense team doesn't put up evidence on damages, doesn't introduce what their number is going to be, doesn't try to anchor the jury, then the plaintiff gets to be the referee and just give the number to look at. I mean, Sarah, you've probably seen it. We've seen the cases where the plaintiff gets up during closing and say, ladies and gentlemen, I was going to ask for $150 million, but I think that's too much. But I think half of that $75 million is exactly what this plaintiff needs. And then the jury thinks they're doing everybody a favor by cutting that half and awarding $37.5 million, because the defendants has said nothing about what they think the value proposition of the case is. And I also think that, and this is a tough one, we on the defense side have to be a little bit more loose in terms of the pocketbook on getting these cases ready early, on spending more expense. We're seeing it a dynamic right now, and I'm not talking about the large academic institutions or the large systems that have been managing their own risk for a while, that have high retentions, that know the game, that they're very intelligent in the litigation marketplace. We're seeing more and more insureds who used to have a $50,000 deductible now facing a $500,000 each and every retention, where they're retaining their own risk, but they're kind of out of their depth on how to handle litigation, and they're very hesitant to spend money or expense. I think we need to change that dynamic. I think that the pennies that the defense bar saves on the front end, they get clobbered on the indemnity side when they don't prepare the case right. So I think we on the defense side need to change that dynamic. We need to be more aggressive in our advocacy for the defense. We need to attack damages fully from the get-go. We need to be prepared for reptile theory and how to defend it. And I think if we do that as a community, as a defense bar getting together, I think we're going to be able to confront these high awards. But I think Sarah mentioned it. I don't see any end in sight until we start to do things like that. I mean, until a legislature comes in and limits it by caps, which we're already seeing to start to fall apart, or the defense bar, we get together and we find a way to confront this and keep these damages to compensation as opposed to a lottery.
Thanks, Bill. Sarah, do you think the catastrophic verdicts are going to continue to rise for medical professional liability claims, or do you think we're hitting the top of the bubble?
This is an easy one, Shelley. For me, yes. In a word, yes, yes, yes. I believe catastrophic verdicts are going to continue to rise. To what Bill stated, unless we can gather the troops and really pull together as a defense strategy and really focus on what it is that we can do to bring these down. Ultimately, though, I think that all of the issues that we've talked about today are contributing to the catastrophic verdicts becoming the norm. And the new norm, and I don't see the bubble bursting anytime in the near future. Bill, do you have a different opinion?
No, I agree. I think that it'll just continue unless we get it under control. And, from the defense perspective, on the defense side, we can't wait for the benevolence of various state legislatures to come in with caps. Like for example, Illinois, never going to happen, ever in Illinois. And most other states, we're going to see it start to evaporate if they start to follow what's going on in California with micro. So we have to be the ones that take the bull by the horn, so to speak, and develop strategies and implement those strategies so that we can be more effective in the courtroom and try to keep those damages down. But it is going to run away unless we do something like that. And one of the keys I really think is not just talking about it. I mean, I've been to several meetings where, great ideas are discussed and then you never see anything about them. I mean, one bright person, not me, once said that great vision without execution is nothing more than hallucination. I think we need to start executing on these strategies, and that's the only way we're going to keep these verdicts down. Otherwise, there'll be no control and they'll continue.
Well, unless you guys have anything else to add, I think we're up to our time here. I want to thank you both. It's always a pleasure listening with you and sharing with you and speaking with you. So again, thank you. And thank you to everybody out there who's listening. We hope that you enjoyed the discussion.
Thanks, Shelley.
Thank you, guys. Bye-bye.